Hey YouTube, I'm Ali, this is Gaming Indoors, and this is a brand new background because I've moved rooms. Well, you're not interested in that, are you? No, you're interested in the subject of today's video, which is all about protecting our games and game ideas with copyright. Now, as always, I've gone to a professional, someone who is passionate both about the subject, but also about our hobby, and I've found the perfect guy. I'm going to introduce him in just a sec. I'm also going to introduce a quick waiver. We are talking about legal issues here, and the information I present and that Zachary presents is really for information you need to go and seek your own advice. But let him say that for you. No, let him say that for me.
Yeah, before we get started, let me just say, I am a lawyer, a video game and board game lawyer, but I am not your lawyer, listener, watcher, viewer. So this is legal information, general information, but it's not legal advice. So if you have a problem, find your own lawyer and talk with them.
Okay, with that out of the way, let's talk about today's subject. Today's subject is copyright specifically. In the next episode, I'm going to be talking about patenting, trademarking, and a bunch of other things. But today, it's all about copyright. What is copyright? How does it affect us? Do we need to register it? Will it cost anything? What protection does it actually cover? All of these are really key things to know because there are a lot of people out there, and myself included to begin with, who are really shy about sharing our ideas in case they get stolen. Let's see what a professional says about this whole topic. Enough rambling from me. Let's kick things off with an introduction.
I am Zachary Strebeck. I am a video game and board game lawyer. So that means that I don't appear in games. I am a lawyer for creators of video games and board games. My story goes back to the late 90s, where I started off in animation for children's edutainment games that came on CD-ROMs and featured animals and Fisher Price and, you know, Jurassic Park and all kinds of silly games back then. And so, yeah, my background was in, you know, I did animation and concept art and puzzle design and things like that for those kind of games way back when. You know, fast forward a little bit, the company closed down, and actually I wasn't very good at animation. I wasn't particularly good at that. So I went back to law school and, I don't know, when I became a lawyer, I decided to go into, you know, continue my passion for games and try to represent game developers. And so, you know, while I was in law school, I got really into, I guess it started, I wanted to become a Scrabble expert, you know, like where you memorize all the words and do all that stuff. So I started doing that. And, you know, at some point I kind of maybe researching that, I found a board game group in my area in Southern California. And I started to meet up with these guys. And, you know, first thing I did when I got there, we started playing Dominion and started playing all kinds of other, you know, great board games. And I don't know, just had a blast. And that, you know, sort of reignited my love for games when, you know, you're sort of concentrating on law school. you don't have time for much else. But I started playing games, and yeah, I knew that this was the industry for me. So, you know, I jumped back into it, but on the other side, on the business side of things, as an attorney. And for the last almost 8 years now, yeah, I've been an attorney representing game developers, and I love it.
Okay, enough of an intro. Let's talk about copyright. What exactly, technically, is copyright?
It's an exclusive right over the duplication, publication, performance, and all kinds of other rights that you have bundled together over original creative expression. So if you write a story, if you draw a picture, if you do dance choreography, all these things, you know, a song, all these things are copyrightable because they're original creative expression.
So how does copyright apply to my game? What specifically can I copyright in my game?
A lot of it, actually. So the artwork, the graphic design, maybe the overall design of the board, maybe the rules text, and you know, the flavor text on the cards, all the text you've got in the game, all of that is copyrightable. Where you run into non-copyrightable things is it's something called the idea expression dichotomy. Right, that's what we call it in copyright law, where there's a divide between the ideas themselves and the expression of those ideas. So if I have an idea, I want to, you know, draw a dragon, right? A blue dragon, and he's got, you know, a mohawk or something like that, right? Okay, that's the idea, a blue dragon with a mohawk. So I draw it, I draw a picture of it, and that, as soon as I draw it and put it on the page, I own copyright rights in that drawing, right? But someone else could draw a blue dragon with a mohawk, and as long as it's not copied from mine or what they call substantially similar to mine, it's not like the same exact drawing, then they're okay because they've just taken the idea of a blue dragon with a mohawk and created their own version of it. And that's okay because you can't copyright the underlying idea. You can only copyright how you've expressed that idea. That's why we can have, different versions of the same game, but like, you have Apples to Apples and you have Cards Against Humanity, where they're two games where the rules and the mechanics and sort of underlying ideas behind the game, the functional parts, are the same, whereas all the creative expression that comes up from those, the text on the cards, the graphic design of the cards, all of that stuff is totally different.
Okay, so when does copyright come into existence?
So there's two things here. Yes, as soon as you create it, you have copyright rights, but you can't really do anything with them. You can't sue someone for copyright infringement until you have a copyright registration. You're going to have difficulty, maybe like if someone posts a clone of your game up on a website where they can print and play. If you try to file a DMCA takedown, which is a way that you can easily sort of tell the web host to take that material down, and that person files what's called a counter notice to sort of say, no, I actually have the right to do this. Well, you need to actually sue them for copyright infringement before you can actually get it taken down. So if you don't have the copyright registration, you're not able to file that lawsuit. So, I mean, there are benefits. You're limited in what you can do if you don't actually have a registration. Now, I should be clear, I'm a US lawyer. This is about US law. I don't know, other countries might require that you, or may not require that you have a registration before you do that.
Obvious question next, what does copyright registration actually involve?
The process is not, it's complicated, but it's not complex. Maybe that's the way to differentiate it. There's a lot of information you need to put in there, and there's a lot of terms you need to know, like who is the author versus who is the claimant. The author is the one that actually created the work, or if it's an employer, employee, or a work for hire situation, it's the one who commissioned the work, who had the employee do it. But the claimant is the person who's claiming the rights. So the author, if I draw a picture and I assign the rights to it to that picture to you, you are the claimant because you have the copyright rights, but I'm the author because I created it. So that, there's a lot of technical terms like that. When you first get in, you need to figure out what kind of application you're filing, and depending on what you're creating. So for a board game context, depending on whether the artwork is more prominent or the text in the game is more prominent. So a Cards Against Humanity would file as a literary work because it's mostly writing. Whereas a more visual game like a Dixit or something like that, that's going to be a work of the visual arts, we call that. So, and if you screw that up and choose the wrong one, then they will deny your application. And so you don't want to do that. So there's a lot of screw ups you can make along the way, a lot of mistakes. So that's why you hire someone like me to do it for you, so you don't make those mistakes.
So do I really need to get registered?
Well, it depends. If what you've created is a big enough deal that you think selling, it's something worth stealing, I guess maybe is a good way to put it. If you hit that point and it's kind of popular before you've actually published the game, look, I think everyone should file a copyright registration for the work. It's not particularly expensive. The filing fee is $65. I charge just over $100 to do it for you. So in the grand scheme of things, compared to something like a trademark, which is going to cost you over $1,000, or a patent, which is going to cost you $10,000, copyright registration is relatively cheap. You do it when you publish the game, usually. It takes a few months to get it, usually. Sometimes things take longer. But I don't know, in the grand scheme of things, for the benefits you get, I didn't mention another benefit, and I think this is an important one. There's something called statutory damages. So if you have a game that is not particularly popular, but someone still steals it, your actual damages are going to be pretty low because you haven't been selling a lot of copies, and so how much have you really been damaged? If they stop using it, maybe they sold a few copies. So instead of having to prove how you've been actually damaged, you can use something called statutory damages, which are by statute. They're written as a statute, and it's a certain amount of money per infringement. And if it was willful infringement, they triple the damages. So you could be getting up to $150,000 in damages per infringement. The best thing, though, is that you get attorney's fees you're able to get attorney's fees from the other person. So a copyright lawyer will be much more likely to take your case on contingency, which means that you don't pay anything unless they get something for you. They're much more likely to do that because they know that they'll be getting their attorney's fees as well. So we're all making money and everyone's happy.
Is copyright registration region specific?
Yes and no. So yes, each country probably has their own copyright regime, copyright system, copyright office, whatever, the registration scheme. However, there are international conventions. In this case, it's called the Berne Convention, where I think the US signed on in 1989, but a lot of countries had signed on before then, which basically means that each country has to have a minimum level of copyright protection for their citizens, and they will recognize the copyright protection from other signatory countries. So we in the US recognize foreign copyrights. I believe that if you want to sue someone, you're still going to have to file your registration in the US if you want to sue in the US, but they will allow that because you have you have rights in another country. You file as a foreign work in the US.
Now, based on what's just been said, it sounds like I do need to get registered to have a proper legal protection. Is there any value in having a copyright if I don't get registered?
Yes, and I'll tell you why. And this is a situation that happens quite a bit, actually. Where a board game or video game developer will create a game, something gets stolen out of that game, but they have never filed a copyright registration. So they come to me and they say, hey, this guy stole my stuff and they sold this game, and they made a bunch of money. So, we get in there and we write a letter that basically says, hey, you stole our stuff. We demand, you're infringing on our copyright. Here's our legal threat. We demand that you pay us $10,000, $15,000, $20,000, whatever amount we come up with. Depends on how much money they've made, right? And how much they've stolen. But we throw a number out there and try to get money. And, part of it, sometimes they will say, okay, we screwed up, we're going to pay you something. And, the client makes money. Other times they might come back and say, where's your copyright registration? Because we know your legal threats are empty if you don't actually have a registration. And then I'll come back and say, hey, if you want me to, pay the expedited fee of $800 to get the copyright registration done now, I'll go do that. But then we're just going to tack that onto your settlement, and you're going to have to pay for it. So, you go back and forth and fight over that. And sometimes they use that as a way to push back against you. But I don't know. If you wanted to sue them, like if they stole it, but they deny it and they won't pay you and you need to file a lawsuit, you can't do that without the registration. So the problem is you have two choices then. You either wait 3 to 6 months, maybe longer, for the registration to go through, or you pay the expedited fee of $800. And depending on how good your case is, the lawyer may pay that for you and then deduct it from whatever the settlement brings in, or they may not. You may have to pay that. So I don't know. It's just more costs, more risk for the lawyer bringing it if they're paying for it. So I don't know. It's better to have the registration done.
If I think back to Ivan and playtesting, Ivan made a comment about the design process being a community-based one, and I wholeheartedly agree with that. With that in mind, what is safe to share and what's not safe to share with people as I develop my board game?
Okay, so you share your game. The chances of someone making their own version of that game, I mean, there's a chance, I don't know. It's pretty small. It's something that if you talk to any developer, or designer that's had a lot of the games out there, I don't think there's a one of them that will tell you not to get playtesters playtesting your game, or to, get your game out there early and often, right? You need as many eyeballs on it as you want, or as you can get. And having, the fear that someone's going to see, you can't live in fear that someone's going to steal your stuff all the time. There are so many ideas out there that are ready to be made into games. Any designer will have dozens of ideas probably of games that they could be making. If you make one, I don't know, I guess if there's something super innovative that you really want to protect, you might want to look into maybe patenting the method behind that. But again, it's going to cost money. So, unless you're, Wizards of the Coast, you're probably not patenting all your game ideas.
Now, along my journey here to learn about game design, I kept on hearing of stories of people taking photos with their prototype ideas, or posting something very publicly on Reddit, or going to the post office and mailing themselves the details of their board game, all in an attempt to protect themselves and to prove that they are in fact the inventors or the creators of this particular game. Do these activities have any legal credibility? Do they keep me safe?
No, I mean, they don't have any legal effect, except maybe to show evidence that you created something on a certain day, before someone else. But it doesn't really matter. I mean, you just show, your files were saved on a certain day, or you posted on the internet on a certain day. I don't know. I think you should be posting on the internet. This is something we call the poor man's copyright, where you mail it to yourself. They actually taught me this in art school. I don't know. It's a thing that it's sort of like a legend that goes around with artists and designers and all that it's a way to protect yourself. It doesn't actually give you any protection. The protection happens when you put it on paper, when you save the file on your computer. They call it fixation in copyright law, when you fixed it in a medium of tangible expression. That's the wording. Save the file, write it down, record a video, something like that. You've fixed it. You have the copyright rights.
Now, I've tried to keep a minimum amount of me in this video simply because I think Zachary had so many good things to say about a very complex subject. And I think he's done really well in breaking it down into something that even I can understand. The key elements he spoke of are all here in this video about protecting our board games. But let's say we've got to the stage where our playtesters are all happy with it, I'm happy with the game, and I'm ready to go to a publisher. Do I need copyright registration or copyright protection or anything else when I go and pitch to a publisher?
If you're a publisher and people are sharing their prototypes with you, and you're going and saying no, but then still publishing anyway, you're going to be out of the industry very quickly. I think you're not going to be getting any more pitches. So, publishers don't do this, but they also don't sign NDAs, and they also don't sign contracts that say they won't make a similar game because they might be working on a similar game already. So they're not going to sign something like that. A lot of designers are so afraid to pitch publishers, but any reputable publisher is not going to be doing these kind of things. So I don't know, pitch away, I say. If you can get a pitch date, go for it.
Well, folks, I think that's a great place to draw a line under this particular video. I want to say a huge thank you to you, Zachary, for taking time out to speak with me. I learned a ton. You took a very complex and potentially very boring subject and really infected me with an enthusiasm about copyright and the understanding of it as applied to a board game. That sounded like a lot of words. But the point I'm trying to say is I really appreciate you taking a really complex subject and making it so simple that even I can understand. Next time we engage with Zachary, we're going to be talking about patenting, trademarking, licensing. There's another ton of interesting and useful information, especially if you're going to Kickstarter in that episode, but that'll be in a few weeks' time. For now, folks, I want you to crack on with voting if you haven't done for our current board game that we're developing. And I did talk very briefly with Zachary about any legal issues. He said we should be okay, so I'm comfy with that. Do vote on that. If you don't know what I'm talking about because you're new to the channel, firstly, go and subscribe. Secondly, go check out my previous videos all about building a board game together, and get involved, get acting on the vote because that draws to a close on Sunday, and that will determine how our game is going to be won as such. Yes, next time we speak, we're going to be talking about the next part of our game development series. So there's so much to do and there's so much to look forward to. Until next time, folks, take care. Board games. I think I'm going to go with Blockmania. What a classic game.